I'd now like to invite our own Alex Tsarkov to the podium, to the dais, and he has a panel here for us to speak on some of the judicial and legislative aspects of this. Justice up here, and also Judge Devlin. That'll be fine, thank you. Alex?
For those of you who know me, know that I love talking about bail. It's really been a fascinating day for me, and I hope it's been that for you. There you go. Thank you. It's the legislator in the room. So we have about 1 hour for this panel. We have to be done on time because we promised to Justice Daniels that we'll get him on his flight on time for what, 5:15?
Yeah, I have to be back at work first thing in the morning in Albuquerque, Santa Fe, rather.
So we'll do our best. Lots to cover, not a lot of time. I'll start it up with a few questions for the panel, and then we'll kick it to the audience. So if you have questions, keep them in mind, and we should have plenty of time for that. With that, I'll let our panel members introduce themselves, and we'll get started. David?
I'm David Labriola. I'm a state representative. It's good to be here. 1985 graduate of UConn Law School. We were the first graduating class here at this campus. I represent the towns of Oxford, Naugatuck, and Southbury. I'm in my 8th term. Each of my terms I've served on the Judiciary Committee, which is my favorite committee by far because it is bipartisan in just about every way. It really does not, we don't not have partisan votes. And I've had a special interest in criminal justice. I'm an attorney who practices criminal defense for over 30 years now with my brother in Naugatuck. Good to be here.
I'm still Justice Charles Daniels. And I haven't checked my emails in the last hour, but I think I'm still the lead named defendant in Collins versus Daniel, pending in the federal court for the District of New Mexico, although we have a motion to dismiss for failure to state a claim that I expect to be ruled on at any point.
Yeah, I'm Robert Devlin, and I'm still a Superior Court judge. And for 2010 to 2017, I was the Chief Administrative Judge for our criminal division. Our present Chief Administrative Judge, Judge Joan Alexander, is here in the audience, so I'm pleased to see Joan here and a lot of my colleagues. And the photographs around the room for some of my colleagues as well, so it's great to be here.
Okay, thank you. Let me begin with a question for Justice Daniels first. There's no question that there's been a tremendous amount of activity in the bail reform. We talked about litigation efforts. We talked about some policy developments in New Jersey, in New Mexico, in the Cook County. Some make a case that we are at a tipping point in bail reform where it's just inevitable in this country. On the other hand, most states still rely on money bail. Many states have bond schedules. Many don't have any pretrial agencies, and they don't utilize risk assessment. From your perspective, where do you see this movement going? Are we in fact at a tipping point on bail reform or not?
It's hard to define tipping point. I don't think it's inevitable that we're going to succeed. But my modest projection is that we will succeed. There are several things that have to come together that I see coming together nationally. Although actually a minority of jurisdictions have made substantial progress, virtually all are looking at it and starting work on it. And I think there's a great deal of movement in the direction of the kinds of reforms that we're talking with, both to better protect the community and to better provide equal administration of justice and to minimize, if not eliminate, the role of money in making distinctions between the people we hold pretrial and the people we let remain at liberty. But it's going to take a lot of work. We've been working on it in New Mexico for 3 years now. I'm personally committed to spend several more years on it. I'm reaching the end of my shelf life as a justice on the court. I'll be 75 in January, and some people retire by that age. And I may retire within the next year or two, but I plan to stay involved in this work on a volunteer basis, serving in a support capacity for the court and the justice system, because you clearly can't just put words on paper and walk away. It takes a lot of work to overcome the obstacles, both the financial opposition of the moneyed interests, not just the bail agencies, but those money interests behind them that finance the operations of these bail agents. It takes a lot of work to go through the community education of people within the justice system and without the justice system, and those in political positions, policy-making positions, to get away from this false concept that the amount of money a person can pay has something to do with either likelihood of appearance or protection of the community. It takes committed leadership. You have to have a coalition, a broad-based coalition. This has been talked about before, but unless everybody is committed to working together on this, and unless you have someone in each jurisdiction or some groups of someones to spearhead the effort and just stay on top of it and be committed to that, it will all fall apart. We've talked about the preventive detention aspects of it. We've talked about the kinds of rules that are needed to make sure we don't incarcerate people for just not having money. But there are other parts of reform, too, that we have to look at. One of them is the pre-release evaluation process. The risk assessment tool is a useful instrument because it helps judges make better judgments, and that's what judges are supposed to do. In the past, to the extent judges have made any judgments at all about the likelihood of flight or danger to the community, it's been based on sort of an ad hoc determination based on it feels like this, it feels like that. And whenever we make decisions about what systems we're going to put in place, we have to think compared to what. You can't make a public policy decision without considering the realistic alternatives. So despite the flaws of these risk assessment instruments like the Arnold instrument and others, you have to compare it to what the judges would be making their decisions on if they didn't have the assistance of that. You certainly don't want to consign justice to a computer program without individual judgment to have the ultimate override. And our rules in New Mexico allow for risk assessment instruments, but don't make it the controlling factor. It's just a tool for the assistance of the court. And the fact is that we're not going to be able to predict with absolute accuracy who is going to be a danger and who is going to be a flight risk. We know there's some things we can do to reduce the odds of both of those things happening in various kinds of conditions, various kinds of tools like the reminders that our dentists and doctors and dog groomers and other people use to try to remind us to make our appointments on time, and other kinds of things like that. But we really need better pre-release evaluation of offenders, and that involves pretrial services offices and so on. It's not something that's created, a need that's created by bail reform. It's always been necessary, even with the money system. And we also need post-release supervision. That takes money. Those are public policy issues that the political forces have to deal with, how much money they want to spend on making sure someone gets to court or making sure someone is supervised to ensure compliance with the conditions of release. But that's something we've always needed and doesn't depend on the other aspects of bail reform. But I think I am cautiously optimistic, Alex, that we are going to succeed this time. And it's the first time I've thought this in 50 years of looking at the release and detention system in the United States. But it won't happen unless we really stay personally committed and realize that this is one of the most important aspects of improvement of justice that we will ever face in our professional lifetimes.
Judge Devlin, we just came back from New Jersey. We had 12 commission members and their designees. We also had Representative Rosa Bimbas come with us. I'm wondering if you could talk about your experience there, your takeaways, and as part of that, are you more or less encouraged now after that trip about the need to move to a no money bail system?
Sure. So we had a very, I think, diverse and balanced group that went to New Jersey. We had members of our Sentencing Commission. We had representatives from the State's Attorney's Office, from the Public Defender's Office, from the ACLU. We had Representative Rabimbis came, and it was a good trip. It was a 2-day trip, and I would say, you know, it's, I guess my overall impression was that I'm both encouraged and somewhat discouraged by the trip. The first day, we met with what I would call the headquarters people. You know, these are the top officials in New Jersey that talked about, and correctly talked about, their efforts to change the law, to abandon the money bail system, to implement the constitutional amendment, and then the 2 years that it took to sort of put through the changes through court rule and statute. But then the second day, we actually watched it happen. We actually met with judges and lawyers that actually make it happen. And it's hard to make it happen. I mean, it's not, actually, quite frankly, Connecticut does a very good job with the system that we have. I mean, a lot of things that have been talked about today, we have, implemented it. We've had a pretrial, I've been a judge for 24 years. We had a pretrial service system in Connecticut for at least that length of time and longer. We have, systems like AIC programs, and we have people, we can put people on into drug treatment and pretrial services. We can do a lot of things. We send people text messages to come to court. If people don't make it to court, we send them a bail commissioner letter, and we've had like a 40% success rate for people to come to court just by the cost of a first class stamp. Our failure to appear rate in Connecticut is about 14%, which is really quite good compared to national averages. So it's a bold and good idea that New Jersey is embarking upon, but I have no illusions about the fact that it's a real road that is going to require lots of sort of halting progress with it. So overall, I was impressed. There are a lot of great people down there in New Jersey, which we got to meet, and I enjoyed the trip a lot. I think I took a lot away from it.
So there are two approaches to bail reform. One is to work within the existing structure of money bail systems to try to improve them. The other is to abolish money bail completely and make release and detention decisions strictly based on risk to the community and risk of flight. My question is, which approach is preferable? And second, can true justice be achieved within the existing framework of money bail? And this is for whoever wants to take it up.
For whom?
For you, if you want to take it up.
I'll be glad to. I think a good big case can be made for doing what the 4 states in this country have done since Kentucky first did it back in the 70s, of joining most of the civilized nations in the world and absolutely prohibiting the sale of money bail bonds and abolishing the role of money entirely in our pretrial justice system. It's a big step. New Mexico has not taken it. There are political difficulties that are very serious challenges to getting that done. We've taken a more moderate step, but like New Jersey and the District of Columbia and others who've taken the step to allow judges to detain people who are proven high risks and to provide that a money bond can't be resorted to unless it is the last available alternative for those people who are not detainable as high risk. As a practical matter, the role of money has been virtually eliminated without formally abolishing the possibility of money bail. And as I said before, public policy choices are often, almost always, matters of what's the alternative in the real world. And I think that that probably is a pretty reasonable accommodation in the real world. I think if you can practically minimize the role of money in the system, you'll achieve substantial reform, and it is an achievable reform.
There's a question for Representative Labriola. We have seen successful bipartisan efforts on bail where both sides of the equation have been addressed, release and detention. We've seen this in New Mexico, we've seen this in New Jersey, where Chris Christie was one of the champions of bail reform. We have Senator Kamala Harris teaming up with Senator Rand Paul to get states to abolish money bail. Do you see that kind of opening for a bipartisan reform effort in Connecticut? What are the opportunities here, and what are the obstacles to a comprehensive reform?
Yeah, I see an opportunity. I mentioned the bipartisan nature of the Judiciary Committee. I see my former colleague Bob Farr, who was the ranking member on the Judiciary Committee, is here. You know, and I just left the Capitol. I see some lawyers and staff from LCO from the Capitol are here as well. We had a House Republican caucus. There's a House Democrat caucus going on right now, which is why neither Representative Stafford or Representative Tong are able to make it here. So we just finished our caucus, and we were discussing the bipartisan budget proposal. We're caucusing again Monday. The Senate Dems and Senate Republicans are caucusing on Monday as well. So that's an instance where, in the middle of this budget crisis, on a bipartisan basis, our leadership came to a tentative agreement. That's breaking news. So I do see there's an opportunity, and Alex, you and I have talked about this proposed constitutional amendment. I would have an open mind to it. There are some obvious issues that I see. One, financial, since we're talking about the budget. You know, currently our arraignment hearings are pretty quick, and the resources, just the resources alone, or just the time in the courtrooms to have these evidentiary hearings on whether or not to detain somebody, that's obviously going to you know, use more resources. So that's an issue. We've got the whole bail bonds industry. It's a long established, pretty big industry, and it'd be a shame to see them all out of business. And they tell us that they're the ones who are so motivated to go apprehend people who flee. So there's clearly a lot of obstacles that we'd have to examine. I have, since I've been in the legislature, I have long advocated that the bail bond system needs to be reformed in terms of enforcement, because I see a lot of prosecutors here, public defenders, judges, that know that it's sort of the Wild West out in the lobbies of our GAs and JDs, where the bail bondsmen are just undercutting each other and cutting deals that are really not legal, and yet the enforcement and the prosecution against this undercutting is not that much. It's pretty sketchy. But you know, while there are rules in place for what the bondsmen are supposed to follow, they undercut themselves all the time. It's very aggressive, and what it results in is that a judge who, after hearing a case, sets a $100,000 bond, these people are out in the street by sometimes posting nothing or very little. And so that, of course, is a huge issue. So I do think that we need to take a bipartisan approach. I guess I would be remiss if I didn't point out that I have a healthy dose of skepticism on our current administration with the Second Chance Society proposals, which I opposed. I see a slippery slope towards more danger to the public. And that's what people in my caucus have been speaking about, and not just in the bill, but in second chance, in the early release programs, in taking teeth away from our juvenile justice system. And so I think that we need to put teeth back into our juvenile justice system. I think we need to closely monitor all our early release programs. I think that we have to be very careful when we reform the bail system as we just did, and that we make it more likely that people are released for just a whole host of misdemeanors, pretty much every misdemeanor. And you know, the people who work in the system, you know, there's a lot of bad misdemeanors. Some of those misdemeanors are pretty serious. And so to make it less likely for judges to impose bail on those kind of cases, I think is a threat. And I said as much on the floor of the House, that we need to be careful of the slippery slope and instead reinforce the judicial discretion. We have a lot of great judges who have the discretion and the ability to make these decisions. But this particular bill that passed this past year, I opposed because I thought that it was ill-advised, well-intentioned, but ill-advised. And so some of those proposals that I just mentioned were not bipartisan. So would I agree to sit down and talk about, in a bipartisan way, the idea of a no money bond system? Sure, absolutely, but it would be with a healthy dose of skepticism.
Thank you. When we compare the two models, money bail system and a system where release and detention decisions are based solely on risk to the community and risk of flight, how does each system perform for the victims of crime and survivors?
That for me?
This is to the whole panel.
Oh. Well, I would say that you can make the argument that a money bail system is not good for victims because people can buy their way out of jail and then can that I think that is perceived as a great concern for victims. I mean, in Connecticut, we have electronic monitoring, we have protective zones, so we try very hard to protect victims when people are out, and I think we do a reasonably good job of doing that. But a system where people who were truly demonstrably dangerous were held, no matter what their number of questions asked, and who were not, were released, is a superior system. I mean, in New Jersey, one thing that was eye-opening to me is that most of their detention hearings are being held on people who are charged with domestic violence misdemeanors. That is misdemeanors, you cannot be detained pre-trial except if it's a domestic violence misdemeanor, and because of concerns to protect victims, that actually is most of the cases that they're having in terms of, you would think it'd be armed robbers or cases like that, but it's more a DV misdemeanor. So, I mean, to me, I think that in Connecticut, we're doing a pretty good job now, but I think we could do a better job if people, simply because of their income, were able to buy their way out of jail. I mean, some of the terrible, terrible crimes we've had in Connecticut, where people have made bond and committed these homicides, have been people who have had the money to post bonds, and then they go and they murder their ex-wife or something. Terrible, terrible. So, no money bail system, you wouldn't have that.
Any thoughtful analysis of the reality of the money for freedom system has to come up with the conclusion that it does not protect the interests of the victims. It does not protect public safety. It doesn't do it under law. It doesn't do it under theory. It doesn't do it under common sense. The amount of money somebody pays for release has nothing to do with whether they're going to go out and hurt someone. It gives a false sense of security. You'll often see people writing into the editor of newspapers or wide-eyed TV commentators talking about the fact that a judge released someone charged with an offense without having to put up any money, without stopping to think about the fact that that money doesn't protect anybody. In fact, I am going to make a prediction about what I suspect your law is here in Connecticut. I suspect your law does not allow Mr. You Ring, We Spring to have his money forfeited if someone he sells a bail bond to goes out and finishes killing the victim the very next day after release. Am I correct in that?
Yes. I think that's the case all around the country.
It's absolutely the case all over the country. It's the case in New Mexico. And in fact, when the bail industry was lobbying against our constitutional amendment that would give judges the honest authority to deny release for any amount of money to dangerous people, one of the bail bondsmen was talking about how his bail bonds protected the public, and I asked him in front of the committee if he would agree to a piece of legislation that would allow the forfeiture of his company's collateral if one of their released defendants, you're shaking your head. That's exactly what he said. In fact, he reacted more violently. It's as if I had kicked over a hornet's nest in front of him. He was appalled at the idea, and of course he wasn't willing to do that, because the fact is they can't guarantee anybody's safety. And so they certainly wouldn't want to give up their money if the person who bought their bail bond and got free as a result ended up going out and committing other offenses. The evidence-based system, the risk-based system that is being moved to around the country is a significant improvement for the rights of the victims and of public safety over the money for freedom system. When we get bothered by the fact that defendants in misdemeanors or felonies are released without paying money, we're not taking the next step in the analysis, which is saying, so what? What would the amount of money they put in the pockets of a bail bondsman have to do with the public safety after they're released? And the answer has to be it has nothing to do with it.
Thank you. So we have a lot of judges in the room, state's attorneys, public defenders, staff from the pretrial agency, and these are the major stakeholders that make release and detention decisions. But there's a different stakeholder in our system that's also involved in making these decisions of release and detention, and that stakeholder is money, right? So I'm wondering if you could talk about that, what that means to you as practitioners. Well, we often talk about judicial discretion and how that's important to us. And we don't have sentencing guidelines in the state, and that's not likely to change. But how do you feel about this other stakeholder that's not really in the room, but that's so responsible for making these decisions?
Just rephrase that, Alex. I didn't catch that.
So let's say a bond is imposed on the defendant and it's $10,000.
Right.
Two outcomes are possible under our system. The defendant could have the money imposed, or maybe the defendant can't afford the bond and he's detained.
Right.
Right. So the judge is making the decision on the bond with advocacy from the state's attorney, from the public defender, with advice and recommendation from the pretrial agency, CSSD. But ultimately, who makes that decision, right? It's that amount of money, it's the stakeholder money that's in the room. And the question is, how do you feel about that other stakeholder sort of being responsible for that decision?
Well, the thing is, so you take two people, right, A and B. They're both charged with, say, burglary, third degree. And they both have the same, present in the same in terms of criminal record and connections with the community and all that stuff. And so in both instances, our risk assessment tool is going to make a prediction or a recommendation for bond for those two people. And say the bond is $10,000, like Alex said. So someone who could come up with about $1,000 is out, and someone who cannot come up with $1,000 is in. But they pose the same risk. So as a society, we're okay with the guy with $1,000 walking around the streets with us. I mean, we tolerate that risk. And the only reason the other person is not out is because they don't have the money. I mean, there's something morally wrong with that, actually, that we'll tolerate this risk if you have the money to pay a bondsman, but we won't tolerate that risk if you don't, because in those that's the key. It's not so much the judge was set an incorrect bond. It was a reasonable bond based on the risk factors that were presented. And if you're a money bond system, that's how you value risk. You value risk with an amount of surety bond that you set. And we let lots of people out on their own recognizance in Connecticut, but we set plenty of bonds too. But to me, that's the key point. So you have the same risk, one person's out, and as a society, we'll tolerate that risk with that person. Burglary's not good, but it's not axe murdering. But we won't tolerate it with someone else simply because they don't have the money to post a bond. To me, that sort of encapsulates what's unfair about our current system.
There's another, go ahead.
I think that this idea that there are a whole host of people sitting in jail who got arrested for stealing a loaf of bread and can't post the bond, I think that's not accurate. We actually saw some fudging of the numbers the last time we went through this debate. And so, we're in a democracy, and a lot of these things are going to be litigated in the election system in our election next year. And not only for governor, but for the legislative seats that are up. And we saw it last time, and these kinds of issues came up a lot, having to do with early release and our criminal justice system in general. And the people that I represent, I think the people of Connecticut, they want to make sure that the rights of the victims are thought about and are considered. And that's why it's so important that we have strong support for prosecutorial and judicial discretion, and that, yes, it's important to have a second chance society, but not to the detriment of public safety. And so if mine is a sole voice, it will remain the sole voice, but I will continue to speak out on behalf of public safety, because that, I think, is the most pressing need. Alex, you and I talk about this all the time, and one idea that this constitutional amendment, changing it so that there could be the very serious cases where no bond is set at all, we would have to change the Constitution for that. So I'd be open to that. But I just know from the way the system works that elections have consequences, and so you're going to see that these exact issues are going to be parts of the gubernatorial campaign coming up, as well as legislative campaigns.
And when you're talking about money as a stakeholder, Alex, money is the mother's milk of politics, as they say, and the bail industry puts a lot of money into legislative and judicial races. In fact, a few years ago, before we started on reform in our state, when I was Chief Justice the first time around, I got a call from the presiding magistrate judge in the county of Santa Fe. Said he wanted to see me. He'd been visited by two heavyweights in the bail bond industry in New Mexico, told that he wasn't requiring enough monetary bonds in his court. And he said, well, I'm following the rules that have been in effect for decades, that I can't require a money bond unless a non-monetary condition of release order wouldn't suffice to ensure the appearance of the defendant. They said, you don't understand, you're hurting our business, and if you don't start setting more money bonds, we're going to run someone against you. He came to me because he was concerned about that. That happens all over the country, and I'm sure it hasn't happened to you in your legislative races, but often these bondsmen contribute heavily in legislative races too, and they expect someone to have an open door for them, as they did in the New Mexico legislature when we faced their opposition and faced some backdoor maneuvers during the course of our constitutional amendment. But there's one other aspect, Alex, to your question about money as the stakeholder. Judge Skelly Wright of the District of Columbia Circuit Court, United States Circuit Court of Appeals, wrote an opinion once that the judge isn't ultimately in control of who gets released. Judge Wright pointed out that the judge puts a money amount on the bond, but it's ultimately the bondsman who decides whether that defendant is going to be sold a bail bond. They can refuse to do business if they choose, and despite the fact the judge has said this defendant shall be released on a certain amount of bond, if the bail bondsman doesn't sell it to him, the defendant doesn't get released. But more importantly, even if the judge expects the bondsman to charge the 10% premium, which is sort of the rough industry standard around the country, and in some states like New Mexico is set by a price-fixing statute, the bond lobby has gotten through the legislature that makes it unlawful for a bail bondsman to sell a bail bond for a 5% premium or a 1% premium or have any price competition there. They still have not outlawed no money down, easy payment plan bonds. And if a judge expects that a defendant is going to have to come up with $10,000 to buy a $100,000 bond, Mr. Bondsman can still sell one of those 0% down on approved credit, maybe get grandma to put her home, mortgage her home to the bondsman, who in New Mexico have ended up taking over a lot of homes. If you look at the property records in the county clerk's office, that defendant can get out no matter what the expectation of the judge was. And the public often will blame the judge for any kind of offense committed by someone who has bought his way out of jail, and the judge's only answer, which is often political cover, is, well, I thought he'd never make that amount of bond, sort of admitting to violating the Constitution by trying to set a bond the defendant couldn't be expected to meet. It's a national problem that exists in virtually every state in this country, and I think this movement toward the change is going to protect the victims a lot more than the rhetoric of the bail bondsman. The reality is that predicting dangerousness or flight is a matter of predicting future human behavior, and no one can do that perfectly. What we have to do is try to improve that process, but the only way to absolutely guarantee that a defendant who passes through a courtroom is not going to commit the crime in the future is for us to arm all judges with a .45 and just shoot the defendants dead at arraignment. That's true. That's the only way to guarantee it. Or to lock them all up, to say, you're presumed to be innocent, but we're going to keep you in jail until and unless we have your trial. I don't think either of those alternatives is anything anybody would seriously contend for. So we ought to look at how we can better predict future dangerousness, how we can better predict future flight risk, and try to come up with a system better than who can pay money to a bondsman or make a deal with a bail bondsman.
It's true that the bondsman lobby at the Capitol, as do all the stakeholders. I see many of them here in this room. Actually, in this past year, this bill that passed, the bondsmen were okay with it because they really weren't hurt. I was part of the minority of people who voted against and spoke against this year's bill because I thought it was a threat to public safety. And I talked to some prosecutors. I'm not going to call them out, but there's actually a couple of them are here who said to me, you know, these misdemeanors, a lot of these misdemeanors that are being listed are serious. And so what's going to happen, one of the unforeseen consequences of this bill is that a particular set of facts, the police or the prosecutors are going to charge a defendant with felonies out of the same set of facts. So, in other words, they're going to find a way to make sure that these defendants are held. And if we send the signal to the judiciary to let people go on virtually all misdemeanors except for failure to appear in domestic violence, that's the wrong signal. And why not return it to what we had before, which is judicial discretion? We have a fine group of judges here in Connecticut, and they're fully capable of making those decisions. So the bondsmen were actually okay with this particular law.
But doesn't the money-based system take discretion away from judges? In that instead of making the decision about release or detention, we're actually making the decision about what's a reasonable bond, and that can go either way.
That's the that's the discretion, that's the decision that's being made by judges, and that's our system. So, no, I disagree with that.
Well, I have a lot more questions, but why don't we kick it to the audience and see if you have any questions.
Hi. Thank you very much. When we talk about removal of judicial discretion, I have one question on that. In the removal of cash bond, or the removal of money bond situations, specifically with regard to warrants, where a judge has a great deal of discretion right now, I wonder if anyone can talk about the impact on low-level offenders, such as, for example, I mean, look, we saw the example with the O'Donnell arraignment, which I think most people in here hopefully would agree would be exceedingly rare in the state of Connecticut right now. But when you have somebody who repeatedly fails to appear to answer to motor vehicle charges, whether it be evading, causing accidents when they don't have a license or insurance, and they cause accidents, and they repeatedly fail to appear in court, and then a judge is asked to order a rearrest warrant, or to issue a rearrest order and have a failure to appear warrant go out, that judge can decide to set a $1 bond, a $50 bond. In this case, I'm wondering, would the court have to impose an order of detention, period, and even a warrant for, let's say, shoplifting, a larceny 6? Would the judge have to order detention? And so, whereas right now a judge might not set a bond on that warrant, would that person, under a no-money bail situation, wind up serving perhaps 3 days in jail before somebody reviews whether or not they should be detained pretrial, and could that have the adverse impact on that low-level offender? I just wonder if anyone can address that.
We've tried to replace the fixed bond schedules in New Mexico with other kinds of early release programs, some of them being release on non-financial conditions according to a set schedule for most low-level misdemeanors. Remember, misdemeanors are offenses that you typically can't get very long sentences on anyway under New Mexico law, and I suspect it's similar to Connecticut law. Generally, the maximum penalty on a misdemeanor is a year. So talking about protecting public safety from a misdemeanor is kind of silly, because a judge could give the maximum sentence on the charge, and what's going to protect the community in the 13th month? I mean, it makes no sense to worry about public safety from misdemeanor defendants. But we also have provided that someone who has a warrant out for failure to appear, who's already been released on conditions, and has refused to abide by those conditions, has to see a judge, doesn't get released automatically, either on a commercial bail bond, which may not have done any good the first time around, or on this release on recognizance for the lower level offenses. They need to see a judge. Also, as part of our reforms and our rules, we beefed up the revocation procedures. Instead of trying to predict which people are not going to show up at trial and erring on the side of detention, we suggest judges hold that club over the head of defendants, the ability to revoke, and tell the defense, I'm releasing you without any requirement to post any money security, but I'm telling you, if you fail to appear in court, I'm going to send a warrant out after you, and we're going to bring you back to court, and we'll reevaluate your conditions of release. And if we find you've willfully refused to abide by the conditions, we don't have to keep doing what someone once described as insanity, and that is doing the same thing over and over again and expecting a different result. I'll either change your conditions to require something more stringent, including possibly money, or I'll revoke your release entirely. So we're trying to provide more discretionary tools other than just setting a bond a money bond that a bondsman can sell to someone without the exercise of that kind of nuanced decision-making by the judge.
I think to answer Judge Williams' question, though, in a no-money bail system, the judge would not set a money bond they just signed the warrant if there was probable cause. Really, then it's up to the prosecutor. The prosecutor is sort of the portal through which this detention, no detention decision-making is made. If the prosecutor felt the case warranted detention, they make a motion to the court to be a hearing. If the prosecutor felt not so, then the person would be released on some conditions. But we would not get involved initially at the arrest warrant stage in determining conditions of release.
Don, can you hear me? So I guess there wasn't a full, I didn't understand the full answer to the question that was asked earlier, but I guess we're really comparing apples and we're comparing two separate systems. I know there's been some pushback that there's some focus on jeopardizing, that changes to these systems or going away from a cash bond or a money bail system will jeopardize public safety. But how does that interplay with the example, the specific example that Judge Devlin gave, which is in the current system, two people charged with a similar crime, they get $10,000 cash or surety bonds set, and one of them makes it and one of them doesn't. So to say that a system that's not the cash bail system, we get rid of that, is safer, I think that doesn't make sense. So we're comparing it to what we have now. So is it safer or not to have a no cash bail system? And then second, I think until we get this process, and I'm hoping this will go through, but legislature processes are not very quick, I think we can do some things on our behalf. Right now, the whole point of the surety, right, is to assure they pay some money, and if they don't come back, the bondsman will go after them or they'll owe some additional money. But many times they've already given that fee to the bondsman. For folks like myself, the public defenders in the room, and the people that represent indigent clients, that money disappears. It's gone. So at least in the meantime, I recommend that we push towards going through that list that Connecticut has of non-surety bonds, 10% to the court. So at least those folks, until we get rid of this cash bond system, can get that money back. And in fact, having that money still kind of on the hook, I think incentivizes people to come back more than necessarily giving a fee to the bondsman that disappears. What do you all think?
But actually, those cash bonds with the courts are better at return rates than the money that's flown the coop already when it was put in the pockets of the bondsman. But here's another interesting thing. There's some studies recently in the last few years that have shown that unsecured appearance bonds are as good as secured appearance bonds. The unsecured bonds are, well, first, a secured bond is where the judge says, I'm going to set a $10,000 bond. You either have to put $10,000 up or get a bondsman to put up $10,000. And if you don't show up in court, that money is forfeited, at least in theory. I suspect in Connecticut, your experience, by the way, will show that the bondsmen often fight to avoid having their bonds forfeited, and that's more theory than reality that they forfeit that bond. And often police officers end up catching most of these failure to appear on traffic warrants and various other things. But the unsecured appearance bond is where the judge says, I'm going to set a $10,000 bond, but I'm going to make it unsecured. If you fail to appear, the court will impose a judgment of $10,000 against you and add it to their fees and costs in this case. There have been some studies recently, there's a particularly interesting one out of Colorado, that have shown that controlling for all other factors, unsecured appearance bonds where you don't put a penny up in front, but you get a judgment against you for that amount if you fail to appear, are as effective as the secured bonds in assuring return to court. Although most of the studies have also shown that other conditions of release can be at least or more effective than any kind of money bond, whether it's secured or unsecured.
I would say that the public defenders have a real role to play in the present system that they're not utilizing as much as they could, which is by court rule, at any arraignment, the defense can ask for a 10% option on the bond, which, for whatever reason, is almost never done in Connecticut. We've been acculturated to sort of the judge is going to set a bond, and it's a cash or surety bond, move on to the next case. Because although that's been a court rule in Connecticut for a very long time, we have very, very few 10% bonds in Connecticut. And I think that's because the judges are not being asked to set those bonds. Now, a judge might not go for it for whatever reason, and the judge may have discretion. That may be a perfectly proper decision, but we have one tool in our toolbox that we're not using, which is requesting the court to approve a 10% option on the bond. So I would encourage the public defenders here to think about that.
You know, I guess you could say by definition that anybody who can't post a bond can't afford it. If they're sitting in jail and they haven't posted bond, that by definition means that they're too poor to pay their way out. I got that line from Alex. But you know, I mean it when I say I have an open mind to a constitutional amendment, because I do think that, you know, it's something worth exploring. The skepticism that I have is from dealing with our current administration, which talks about second chance society, but in too many cases it's really unlimited chance. It's more than not just second chances, however many chances as you want. It's granting pardons perhaps too easily. It's just a whole range of issues that they're promoting. He wanted to raise the age to 21 into juvenile courts, and then he wants to go to 25. I mean, I understand that he wants to enact what he refers to as, you know, progressive criminal justice reforms, but in my judgment, too often it's a slippery slope which endangers the public safety in an effort to try to promote that agenda, which is controversial, shall we say.
Thank you. An issue that hasn't really been discussed today regarding alternatives to keeping people incarcerated but keeping the community safe is the effectiveness of the alternatives. So I just wondered if any of you can speak empirically about how well things like drug treatment programs, alcohol treatment programs, post-arrest, you know, any other alternatives, how successful are they at stopping recidivism?
You're talking about after conviction?
I'm really talking about both, because part of the idea of pretrial is if there are ways of keeping people in the community without endangering the community, that would be preferable to, you know, just automatically keeping them in jail.
That would be rational, wouldn't it? Which doesn't always control in public policy. But sure, we could spend a lot of time talking about post-conviction or alternative to prosecution treatment methods. I'm sure you have here in Connecticut various kinds of treatment courts, as we have across the country, drug rehabilitation courts and alcoholism rehabilitation, those kinds of things, which have statistically been proven to reduce recidivism rates, restore productivity of citizens at a much better rate, and so on. I mean, it's just demonstrable in black and white, despite the political rhetoric that sometimes gets in the way of rational analysis. But in the pretrial context, which I think is our focus here today, monitoring of defendants, which is why I said the pretrial post-release monitoring is an important component, whether or not you have a money system. When somebody is released and they're a repeat DWI offender, when they get convicted, you can't put them in jail for the rest of their lives. They're going to be back out on the community and out on the streets again. You can put conditions of release where it's needed. Shouldn't be done in every case. Tax evasion defendant doesn't need to be deprived of the wine with dinner or whatever. But someone with an alcohol problem can be required to come in and provide urinalysis samples and have revocation proceedings, proceedings back before the court if there's evidence that they're not abiding by those conditions well, drug tests, those kinds of things. There are all kinds of monitoring procedures that, if you have the resources to do, can be helpful in both ensuring the kind of regular contact with the court that's more likely to result in their appearance for the substantive court proceeding, as well as to minimize risks. Ankle bracelets, GPS monitoring are useful for people you want to keep away from somebody else, where the monitoring can help ensure compliance. All those things are much more helpful than just saying, put some money in a bondsman's pocket and we'll see you in a few months.
So in Bridgeport, we have this thing called the Treatment Pathways Program. On the day you're arrested, that very day, if you have a drug problem and you want treatment and you fit in the broad sort of qualifications of the program, which are pretty broad, you get treatment that day. That day, you're in a treatment program. And, you know, look, modern drug treatment is what they call medically assisted treatment, MAT. And so it's really a combination of medicine and counseling. And so they both work. That's the modern model. And, you know, it used to be the best drug treatment programs had a 15% success rate. I mean, 85% failed. We're actually moving that needle substantially in the right direction with this sort of combining medicine and counseling. So in Bridgeport, what we're trying to do is like jump right in on that. If someone gets arrested and they have a drug problem and they want treatment, boom, that day you're in there. And it's really been a really encouraging program to work with. And so I see that as a good model for our state to replicate that. And we're trying to do it now in Litchfield, and I think there's some intention of maybe moving it to other court locations as well.
The late Judge Damiani, who was a mentor of mine and many of the people in this room I know, used to, and I paraphrase, but he used to say that a defendant before him, his job is to determine whether they're a bad guy or not. And so when I talk about, you know, taking a very strong stance on protecting public safety against the bad guys, that's one thing. But as far as people who need drug treatment, alcohol treatment, mental health issues, I strongly support anything that alternative to incarceration that can address those problems. And I always have, and I always will. Because I think that a person who's an addict doesn't necessarily need to be in jail, but needs for society and for that person's family and in general, that the correct way to handle it is treatment itself.
This is a question to kind of follow up on the Chief Justice's points. Have there been any empirical studies showing an increase in those quote-unquote status offenses that Your Honor was just talking about? Like in Connecticut, for instance, violations of conditions of release is in itself a new A or an A misdemeanor or possibly a D felony. Have there been any studies that show, well, when we move to a no cash system, that violating the ankle brace monitoring or violating drug treatments have resulted in more criminal charges compounding on individual defendants?
Could you ask that question again in a briefer fashion?
Sure. So when things are moved to a no cash system and people are released, and you were just talking about conditions of release and the court's ability to deal with them, in Connecticut, they could also result in new crimes in and of themselves as a violation of condition of release.
They don't result in the commission of additional crimes. They result in the person being caught committing more crimes. I think that's what you meant to say, didn't you?
No, in Connecticut, we have an A misdemeanor and a D felony for someone who actually violates a condition of release.
You want to address that under Connecticut law?
Sure. I don't think if there was a no money bail system the person would either be in jail or they'd be out on some kind of conditions. And so if they violated those conditions of release, whatever they were, I think it'd be a similar sort of process in terms of trying to adjudicate, what would be the proper response to that violation. So I don't think it would be either more severe or more lenient. I think it would simply be a different forum in which if someone was messing up while they're out, and it was brought back to the attention of the judge would have to deal with that. Now, it's not necessarily that you put the person in jail, that's like the max option, but there's other sorts of graduated things that could be done to try to get the person in compliance. But I don't think this fundamental change in bail system would really make much difference with respect to that particular problem.
And to kind of follow up on Judge Williams' question from before, under the preventative detention, is that like the ultimate severe sanction, even for some low-level offender, say the habitual person who operates under suspension, and the court puts a condition not to drive unless properly licensed, registered, insured, and they have to get to work, they have childcare, and they keep doing it? I mean, are we going to revoke somebody's? Are we going to put them under preventative detention? Is that a function of what the new system would look like?
I mean, look, the new system, if we get there, is going to require a lot of decisions about line drawing. I mean, and that's what's eligible for detention is one big line you have to sort of think about and draw that with real care. We're sort of in the big picture in this thing right now. We haven't really gotten to the point of thinking about other things. But sure, you'd have to draw lines in terms of how serious does a crime have to be before it's eligible for detention. I would hope that persons who are convicted of operating under suspension would not be detained absent some really terribly egregious circumstances.
In the real world, I'm not aware of misdemeanor defendants being held on preventive detention. In New Mexico, it can't be because the constitutional amendment that passed last November provides that it can only be done if the defendant has a pending felony charge. But even in the jurisdictions that don't have that limitation, I'm not aware of any kind of significant misdemeanor detention practice because it just makes no sense. As I said, misdemeanor offenses not only don't involve people who pose any substantial danger because they're committing offenses that by nature are considered petty by the political branches of government and their prescription of penalties. And the second is the court only has jurisdiction over them for a limited amount of time anyway, so the detention doesn't make sense there. I think that's not anything for you to have to be practically worried about.
Well, I guess one of the considerations is going to be, we don't want a situation where somebody's on detention with no bond and then they're given an offer, and no matter what the offer is, they're going to say yes because it gets them out of jail. And so, again, we rely on the integrity and the discretion of prosecutors and our judges so that that kind of thing won't happen. But certainly, from the defendant's point of view, he or she is going to be highly motivated to take any offer that gets them out of jail that day.
The people who are detained under these schemes generally are charged with pretty serious offenses. They're pretty serious threats to the community. I can see why prosecutors would offer time served in lesser offenses. I would have a hard time imagining prosecutors doing it with people charged with the kind of crimes that result in detention for dangerousness. But I'd be interested in seeing any hard statistical data if there's any kind of practice of a prosecutor going in, persuading a judge that this person's too dangerous to be released, and then offering to plead them for time served after the detention order is entered.
Now, I need to just bring a dose of reality, I think, to the conversation, meaning the last few years have been pretty difficult in Connecticut. So Judge Devlin and Representative Labriola, if I'm understanding this, this new concept, it's going to require a lot of resources in the pretrial stage now, supervision, services, and we've closed courthouses, lost staff. I don't see that happening if we were to move to this kind of a system. I don't see those resources available. And in fact, right now, somebody that has no involvement in the criminal justice process can't get into a drug rehab. So we just don't have the availability of services for people that would be released, and I'd like to hear your thoughts on that. We have to make a commitment to that, and I don't see that commitment being a reality right now for the state of Connecticut.
The lack of resources is a serious problem for the criminal justice system generally and for lots of parts of government. But you have to analytically look at the various components of reform and see which ones require resources and which don't. It does not take significant resources to go from a money system to an evidence-based system. The detention hearings typically are not lengthy. They should be more than the 60 seconds we saw here in Harris County for setting a bond that somebody couldn't meet. But on average, we checked into the jurisdictions that have been doing this. They typically last no more than 15 minutes, 30 minutes at the outside for the kind of presentation of information that a judge can make an informed decision on. The things that take the most resources are things that are analytically separate. The pretrial assessment, which we need now. We should be doing that before we set money bonds now, because we're doing it in an irrational way that has nothing to do with public safety and has nothing to do with likelihood of return to court, because we're doing it just based on how much money somebody has in their pocket. So to the extent we're going to need that in the future, the pre-release assessment, we ought to be doing it now. If we can't afford to do it right now, we may not be able to afford to do it right in the future, but that's not going to change by going from a money system to some kind of assessment of individual risk. The other aspect that is expensive is monitoring of people while they're out. The bail bondsmen don't do any serious monitoring of people. They sell bail bonds, they put the money in their pocket, and they don't have anybody come in and pee in a bottle. They don't have anybody come in and give a drug test. They don't put GPSs on them, the defendants, to monitor them or anything like that. To the extent that those things are important to have, they're important to have right now. In addition, if somebody wants to keep this money system, they ought to at least provide some pretrial supervision now to help better protect safety of others, victims, witnesses, new victims, and they ought to have it now to make sure the defendants are complying with any other conditions in addition to the money set by court. So sure, in a perfect world, we would need all those things. We would want them, I would say. But we need them now, regardless of whether the money system is replaced. So they're analytically separable. I think that we can get away from the money system apart from whether we're going to do the other things that we think would like to do to make the system work even better.
We have those things now, though. I mean, the beauty of Connecticut is that we have this infrastructure right now. We have a really robust pretrial services division that's we check people for drugs, we monitor people, we have a whole array of services like that. We have a risk assessment tool that is better than the Arnold Foundation tool. We've had this longitudinal study going with Central Connecticut State University for at least a decade to validate our tool. So, I mean, Connecticut has a certain base. It's not going to cost much money to change this. I think what it's going to cost is judicial resources. I mean, I think, and that's fair. That's a fair point for us to really consider carefully. And I'm not sort of pushing that aside. It's going to take more judge time, more prosecutor time, more public defender time. If we're going to go down that road, there's going to be detention hearings. I was a federal prosecutor. I know what detention hearings are like. And so that's going to be. So that's the question: is it worth it to do that? But in terms of the basic things like risk assessment tools and pre-sale services, we have all that already. You know, I'm not so sure about that because you'll have some more people. You'll have some more people do that, and I'm not sure exact numbers on that.
How much money is being spent by taxpayers on keeping people locked in jail. Pretrial services, for example, is a lot less expensive than full-time custodial confinement. What's that?
They're not available, that's what I'm saying. The services are.
Well, in a perfect world, they should be, but the taxpayers are paying more money now to do something that's less functional and less just. It's hard to change the way we do things. I've encountered this before. On our court, we instituted electronic filing just a few years ago. You may be way ahead of us on this. And I had so much resistance from lawyers, not a majority of them, but some lawyers around the state saying the sky is falling. You have electronic filing and it's going to be so much more expensive, it's going to be so much more trouble. And they were at the Xerox machine at 4:30 trying to get their papers collated so they could run to the courthouse, spend time going to the courthouse and filing these papers and mailing them out, all these copies. They were resistant to change, as there's a human resistance to change. Now those same lawyers are coming back saying, man, this is the best thing since sliced bread. I can sit in my office and I can send it all in by computer and serve by computer, and there's no more of an argument over, well, Your Honor, I didn't get served with a copy of that. It didn't come in my mailbox when you have the electronic evidence of it and so on. I see the same thing here. And it's almost like that old story of the emperor who got fooled into letting some phony tailors prepare an invisible suit for him and walked around naked. And everyone had been told that he had this fine clothing and only the intelligent people could see the finery that he was wearing. And everybody pretended that he was dressed in the most elegant clothing until this little child said, hey, the emperor has no clothes. I think this money system is going to be looked at in retrospect like that. Once we get past this, we're going to look back on the days when we relied on the money system in the same way we look back on the days when we didn't provide lawyers for defendants in court. And sure, there was a cost involved with that, but it certainly was a significant improvement in justice. I think we're at that kind of a juncture now, and I see that my time is out.
Yeah, on that note, that's all the time we have for this panel. John has some final words for us. In the meantime, there's some surveys on your tables. If you could please fill them out before you leave. We'd love to hear from you, and we'll incorporate your feedback when we have another one of these events. Thank you.